I'll continue the chapter Legislature. Previously, we discussed the structure and powers and functions of the Indian Parliament. Now, I'll talk about the lawmaking process in India. Law is a definite rule of behavior. It is a general rule of human conduct in society which is made and enforced by the government. Each law is a binding and its violation is punished by the state. Constitutional law is the supreme law of the country. It can be called the law of the laws in the sense that all lawmaking in the state is done on the basis of powers granted by the constitutional law, that is, the Constitution. Ordinary law is made by the government, that is, the legislature, and it determines and regulates the conduct and behavior of the people. We need laws and rules for protection from ourselves and others, and also to enjoy freedom to do certain things and to resolve disputes. Before discussing the procedure of lawmaking in India, let us first understand the meaning of bill and its various kinds. A bill is a proposal for legislation which is introduced in a legislature and it becomes an act or law when duly passed by both the houses of the parliament and signed by the President of India. The various types of bills which come before the parliament are money bills, financial bills, constitutional amendment bills, and ordinary bills. Let us discuss them one by one. Money bills deal with financial matters like taxation, public expenditure. Or, in other words, if the bill contains some or all the provisions of Article 110, it is called a money bill. A money bill can be introduced only in Lok Sabha, and that too with prior permission of the President. It should be confirmed as a money bill by the Speaker of the Lok Sabha. The President cannot return the money bill as well as constitutional amendment bill for reconsideration of the Parliament. Financial bills contain some provisions related to taxation and expenditure and also contains additional provisions related to any other matter. Since it includes other matters also, Rajya Sabha has equal say to amend or reject it. President can also send the bill for reconsideration for once. All money bills are financial bills, but all financial bills are not money bills. Constitutional amendment bills can be introduced in any of the two houses without recommendations of the President. They must be passed by each house separately with a special majority. It is obligatory for the President to give his assent to the constitutional amendment bills. Article 368 deals with constitutional amendment bills. Ordinary bills are concerned with any matter other than financial bills, money bills, and constitutional amendment bills. These can be introduced in either house without the recommendations of the President and are passed by simple majority in both the houses. Lawmaking is the process by which a legislative proposal, that is, a bill, is brought before the Parliament to convert it into law. The process of lawmaking begins with the introduction of a bill in either house of the Parliament. A bill can be introduced either by a minister or a member other than a minister. In case minister introduces it, it is known as a government bill. And in case a member other than a minister introduces it, it is known as a private member's bill. A bill undergoes 3 readings in each house before it is submitted to the President for assent. Now let us discuss lawmaking process in detail. An ordinary bill can be introduced in any house of the Parliament. The presiding officer, that is the Speaker, fixes the date for the introduction of the bill. At the stage of first reading, the title of the bill is read out and the copy of the bill is tabled in the House. If a private member wishes to introduce a bill, he must give 1 month prior notice to introduce the bill and seek permission of the Speaker. Usually, a bill is not opposed at first reading, but if it is opposed, then it is put to vote, and if House is in favor of introduction of the bill, then it proceeds to the next stage. Otherwise, it gets killed at this stage. After the bill is introduced in the House, it is published in Gazette of India. This is considered to be the first reading of the bill. Sufficient time is provided between the first and second readings of the bill so that the bill can be printed and distributed among the members of the House. The second reading consists of consideration of the bill, which is in 2 stages. The first stage consists of general discussion on the bill as a whole. The main objective of the bill is discussed. At this stage, it is open to the House to refer the bill to a select committee or to a joint committee of the two houses, or to circulate it for the purpose of obtaining opinion, or it can be straightaway taken into consideration. If a bill is referred to a select or joint committee, the committee considers the bill clause by clause, and it can also make amendment to various clauses. After the bill has been considered, the committee submit its report to the House. Now, the House considers the bill again as reported by the committee. If a bill is circulated for the purpose of getting public opinion, then such opinion is obtained through the governments of the states and union territories. The second stage of the second reading consists of clause by clause consideration of the bill. Discussion takes place on each clause of the bill, and amendments can also be made at this stage. The amendments become a part of the bill if they are accepted by a majority of members present and voting. After the bill has been adopted by the House, the second reading is considered to be over. The third reading of the bill is the final stage in the passing of the bill in the House. At this stage, the bill is not read or discussed clause by clause, but read as a whole. The debate is confirmed to two arguments, that is, either in support or rejection of the bill. In passing an ordinary bill, a simple majority of members present and voting is necessary. But in the case of a bill to amend the Constitution, a majority of not less than 2/3 of the members present and voting is required in each house of the Parliament. After the bill is passed by one house, it is sent to the other house. There also, it goes through the stages just discussed, except the introduction stage. If a bill passed by one house is rejected by the other house, or the houses have finally disagreed as to the amendments to be made in the bill, or more than 6 months lapse without the bill being passed by it, then the President may call a joint sitting of the two houses to resolve the deadlock. If the bill is passed by a majority of the total number of members of both the houses present and voting during the joint sitting, then the bill is considered to have been passed by both the houses. There cannot be a joint sitting of both houses on a constitutional amendment bill. The bill, after having been passed by the Parliament, is sent for the approval of the President. The bill becomes a law only after the President has given assent to it. The President may give assent or may withhold the bill. The President may also return the bill except a money bill with recommendations to the houses for reconsideration. If the House pass the bill again with or without amendment, the President cannot withhold the bill. The President is, however, bound to give assent to constitutional amendment bills. So, what we discussed today was the primary function of Parliament, that is, lawmaking. To sum up, we can say that for every such procedure, a bill needs to be passed in both houses of the parliament. Once passed in both the houses, the bill needs to get assent of the president to become an act.